Now we're at the end of the third week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How can I be prepared for? I'm not. So the witness is just supposed to get up there and just. I'm just like, yeah.
I'm not going to have this commentary. Okay, I'm done. The jury's coming out. Be prepared to call.
So that's a rush to judgment.
That is not a rush to judgment.
It is a rush to judgment. It's clearly a rush to judgment if I'm telling you that I don't have the file.
How am I supposed? You're attempting to delay. So
no, I'm not. I'm not attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks.
And Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah, and they deserve to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I still had another one that didn't have nothing to do with nothing we just talked about. There was a whole nother issue that needed to be addressed that I needed to bring on the record to your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
just like the rush to
judgment.
Time
for evidence to be presented or arguments to be made by the parties.
I can't even present any evidence. You won't let me even put any evidence in the record.
All of these statements made by Mr. Brooks at this time. All right.
That's unfair what you're doing.
The court will address legal matters outside the
presence. Then we need to address the legal matter that I was trying to get to before you rush everything out.
You may call your next witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant. You're supposed to be able to answer simple questions.
Mr. Brooks,
if I'm saying I have to bring
call
it to
your
your
next
attention,
witness, please. That's the stage that
I have to bring it to your attention, Your Honor.
Mr. Brooks,
I'm merely seeking to bring an issue to your attention.
I'm telling you to please. I'm asking you to please stop.
And I'm asking you
because we have the jury present.
I'm asking you.
We need to continue with the evidentiary phase of this trial. Call your next witness.
I'm asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will do that at the next break.
There was a legal matter that needed to be addressed beforehand, so we don't have to take up time, valuable time afterwards to address something that needs to be addressed now. That way, the court and you yourself are on notice.
I will address it at the next break. Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony. We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
so you're going against your sworn oath. You're going against your sworn oath.
Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going to take testimony right now. Call your next witness.
I merely seek to put you on notice, on the record, for something that needs to be brought to your attention and to the court's attention.
And I will address it at the next break.
That's what I'm merely seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at. And we can nip it in the bud before everything starts to roll. And
Mr. Brooks, I will address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're making a judicial determination.
Call your next witness, please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment.
There is a rush to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public servant.
Mr. Brooks,
are you not a public servant?
It is 9:37. Call.
It is 8:37.
Sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next witness,
We had
please.
a legal matter that needed to be addressed. And I'm merely trying to notify the court.
Telling you I'm denying the request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
call. How can you deny something that we're supposed to do before the jury comes out?
Call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this every day.
Everyone is in the courtroom waiting for you. Please call your next witness.
We do this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You can
both?
take a minute
This
to
is the
write down what it is.
This
I'm
is
not
the
asking
reason
you
why
to...
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks,
Do I not have your oath of office?
under
3 of them?
906.11, this court has the authority, as you know.
Do I not have?
Call,
Is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason? That these are three
sir,
of your
you are
oaths
doing this,
right
and
here.
I've repeatedly told you, you can see the jury's here.
You're
You're doing this.
Listen,
we
Your Honor,
need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which kills
In my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor,
presiding over. I'm not going to address
is
that
this-
at this moment.
is this not your
and
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you will protect the
Mr.
United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
we are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I
Call
object to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling, and if not that, an interlocutory, declaratory appeal for this matter, and if not, these need to be stayed until this matter is before a adjudicated court of competent jurisdiction, because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of
Mr.
the
Brooks,
charges against me. I don't even understand that part
I
of it.
understand
I haven't
your
been
request.
provided a complaint. I haven't. Your Honor, there's so many issues.
Mr.
and
Brooks,
I'm not
we will
attempting,
take-
I'm not attempting to
Mr. Brooks,
be disrespectful in any way.
we
I'm
need
not
to
attempting
continue.
to delay the proceedings.
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm
respectfully
going to instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to